And live streaming board.
Correct. Therefore, you find out. Then you saying on the right side somewhere.
Number 1.
I am from the petitioner. I am proxy counsel from the petitioner, my lord, seeking 4 weeks time to comply with office objection.
2 weeks.
Obliged, my lord.
2 weeks for office objection.
22-2. Number 2. MV Charity.
I'm for the appellant in this case, my lord. 2 weeks may be granted, my lord, to be complied with the subjections.
All right, 2 weeks. Granted.
My lord.
Number 3. Giridhar SV.
I appear for appellant, my lords. I pray for a week time, my lord, for complying office objection.
All right, a week's time as prayed. Granted to remove the office objections.
22. Number 4. Mr. Prasanna Kumar.
My lords, I appear for the appellants. My
I
lords.
pray for
Pray
appellant.
for two.
I pray for 1 week's time for the grant time.
1 week for removing of objections.
Number 5. Prasanna Kumar.
My lords, I appear for the appellant. My lords, I pray for 2 weeks time, my lords, to comply with the office objections. My lords.
All right, 2 weeks.
Much obliged, my lords.
22-2. Number 6.
For petitioner, my lords,
Ready?
I will seek a week's time in this, my lords, to comply of the objection.
Week's time to remove the office objections.
22-2. Number 7. Mohammad Taib.
Preparing for the petition, Lordship. This is a PI, Lordship. There are 5 office objections are there, Lordship. In respect of 2 office objection, I have submission, Lordship. Maybe consider and set aside, Lordship.
Yes.
The Lordship petition is the first office objection, Lordship, with respect of certified copy of annexure A, Lordship. It's a tender notice which we have downloaded online, Lordship. Certified copy we cannot produce, Lordship. It may be considered.
Have you annexed the copy of the tender?
Yeah, we have annexed the copy of the tender. Even we had mentioned in our affidavit also, Lordship. It's a computerized copy.
All right. We'll over
And second, Lordship, in the tender, there is call for several other work, Lordship. The relevant our work and all the conditions we have translated and provided, Lordship. Second objection, Lordship. Complete translation of annexure B, Lordship.
Yes.
Other 3 within a week, I will comply, Lordship.
We'll overrule this. No. The office objection 1 and 2 overruled. The counsel for petitioner is granted a week's time to make good the remaining office objections. Give it date.
22-2.
1 week. Oblige, Lordship.
Number 8.
My lord, these are petitions filed in public interest, my lord, concerning children with disabilities. And in the previous hearing, my lord may kindly take the WP 51251, which concerns, my lord, the accessibility of textbooks for children with visual disabilities in schools across the state.
All right. Who appears for the respondent? Yes. AJ?
See my face.
AGA?
Your last may kindly pass on, Lord. My colleagues are appearing, Lord. There must be some.
She did not come from home.
She's there. She's logged in.
Lord, there must be some connectivity problems, Lord. I'll inform them right away.
My lord, there are also some office objections that have now been raised with the petition.
Counter is here.
I may be giving.
Yes, she is online.
Yes.
Let
Madam Vani, have you filed the status report? You are not audible. You are not audible.
Lord, we have filed it yesterday, my Lord.
Yesterday,
Yes, Lord.
so that it may not come to court today.
Lord, there is some delay in e-filing, Lord. We have filed it yesterday morning itself, Lord. The complaints affidavit has been filed, Lord, indicating in detail regarding the braille books.
Not on record.
It's come on record.
No, whether the status report has come on record or not. In some other matter.
Connected.
You filed the status report in connected matter.
Lord, in 51251 of 2019.
Yes, that is a connected matter.
Please, Lord, which pertains to, Lord, the issue of Lord, the braille books to the students with disabilities.
What is your stand?
Lord, we have stated that, Lord, 132 books have already been converted into EPUB 3 format, and it is already made available to the students. Insofar as, Lord, the balance EPUB, balance books, Lord, in EPUB 3 format, within 3 months, Lord, we would be
What is
doing
that format? We do not know. We want to know as to whether you have filed the books under the braille, under the braille, so that the blind children can read from that.
Lord, EPUB 3 format is, Lord, the format which is now, Lord, made available to all children with Lord, visual disabilities.
Okay.
Lord, there are about 400, Lord, 403 textbooks which we have not yet been done, but we have already, Lord, outsourced these things, and then we have sought for 3 months time, Lord. Before the next academic year, Lord, entire thing would be ready. But 132 books we have already.
As per you, when the next academic session starts?
Lord, June, Lord, June 2020.
Not June. It starts in April.
Lord, fiscal year is April, Lord. Academic year is.
Academic year starts.
They have to make preparations on that.
Yes.
It is not that when the classes start,
Lord,
only then you will provide the books.
Lord, not that way, Lord. We have been
The
doing.
admissions are to be made. The schools have to prepare themselves. So for that only the session starts in April.
Lord, Lord, what has happened, Lord? I am told, Lord, we have explained that in the affidavit also. In order to convert one book, Lord, one textbook, it takes minimum 3 days, Lord, for them.
It took time. We granted you time.
Outsourced also, Lord. We have outsourced.
No, this is not done.
There are no outside agencies, Lord, who are doing this. We have also requested, Lord, international agencies to come forward, Lord, but nothing has happened. Email correspondences are going
for last 2 years.
You have not been able to do it.
Steps have now been taken, Lord, since 3 months, Lord.
535, we have been able to do only 132.
We will grant you 2 months more time,
Lord,
and get all the relevant books, required books,
Lord,
filed. That make them available.
Lord, Lord, we will try.
No try.
Lord,
You have to do it.
Lord, there is only one agency, Lord, which is doing, Lord. That's the problem, Lord.
Enough time we have given. Otherwise, we will take very serious view of the matter.
Lord, I shall communicate this to them, Lord. And there was one more direction by your lordships, Lord, regarding how many students are there with visual disabilities across the state. That
report
also,
has number of blind students in government and private schools institutions.
Yes, that we have filed, Lord, after getting the information from the concerned authority, Lord.
How much? How many?
How many? Lord, your lordships will get that, Lord, in annexure. Annexure R4, Lord.
Yes.
There are about 1692 students, blind students, 1692 across the state.
This survey has been done in private schools also?
Yes, Lord. In private schools, there are 533. I'm sorry, Lord. 533 students in aided schools. In private schools, there are 1014 students.
What about government schools?
145 students. Totally 1692. But annexure R4, I have given the details. Page number 32, my lord, your lordships will get to it.
We survey on how many blind children, madam?
Survey done.
This is only regarding blind, lord.
These are over
After conducting survey.
studying. What people who are not studying because they don't have books.
Books are to be made available to only those who are admitted.
They can't study.
My lord, if I may be allowed to submit on these numbers, my lord.
Did you get the report? Did you get the copy of the
My
report?
lord, they have served a copy on me on WhatsApp just yesterday, my lord. I have gone through it. I will need some time to verify some of the details, my lord, especially with regard to these numbers. It appears to be.
You get a survey on your own to verify these figures.
I
What
may
they
be
have-
allowed some time to verify, my lord, with the resources that are at the disposal of the organization that I represent through this PIL. We may be allowed to verify it because it seems a little low, my lord, considering the fact that the census in 2011 itself shows that
All
there
right,
are about
unless you will do some
17,000
exercise, unless you will do some exercise in this regard, you will not be able to know the authenticity of these figures.
True, my lord.
Yes. And we will grant them some more time to provide the relevant books.
Obliged, my lord. The conversion to EPUB, my lord, seems to have been done with 132 textbooks, with 403 textbooks still remaining to be done.
Still remaining, yes.
And this has been the status for 2 years, my lord. It's and if they require.
No, when these 132 books were made available, when? 2
My
years
lord,
back.
they claim that it has been made available in the
Since 2 months, lord. Since 2 months, lord.
There is some progress. Please make efforts to make available all these relevant books, because without that, how can children study?
We have been coordinating with various agencies, lord. The cost is coming too high, lord. 3 lakh, 4 lakh for one textbook, they are saying, lord. So we are finding it very difficult. But then we are getting this done through other NGOs, lord, who are joining hands with the government, lord, to achieve this object.
All right. Learned AGA submit that the status report has been filed. As per the status report, 132 books in Braille.
EPUB 3. EPUB 3. EPUB 3.
Electronic publication, lord.
In bracket
Publication, PUB, pub.
PUB, e-publication, bracket close, have been provided to the students with visibility impairment, and 403 more books are required to be provided, for which efforts are being made. She submits that some more time may be granted to the respondents to provide these books. It is also submitted that a survey has been carried out to identify the students with visual impairment in the schools, and as per the survey, 1,692 students have been found with visual impairment. Then panel counsel for the petitioner wants to verify the figures given by the respondent counsel. This case again on give after 2 months date. One 1st April after 4 months, after 2 months. 4. 4th April. And in the meantime, the respondent shall ensure the availability of remaining books. The petitioner may also get the figures of the blind students verified as per her own resources.
Grateful.
Yeah, next, right? This is my audio.
Yes. Number 9. J.R. Mohan.
For the state.
For the petition first matter.
Respond number 4, there is a special investigation team.
I haven't responded. This matters, Lordship should recall, my lords. Lordships had directed the SIT to file an application seeking specifically leave to file the report they had prepared. I think Mr. Harnally represents this.
We have made an application, Lord, seeking for permission to lodge the final report before the magistrate. On the last occasion, your Lordship observed that we should file an application to seek for such a relief. Accordingly, we have made the application.
May please, my lords, I am appearing.
Yeah, not received, your Lordship. Copy has not been served.
No, I have filed it in 6586 of 2021 and I have served copy on the other side. Not whoever is appearing in this WP, I have served them.
I have not received any copy, your Lordship.
Just a minute. What is the last order?
On 30/11/2021.
9/11. 9/11. 9/11, your Lordship.
Yeah, you can argue.
All right. Now, where is your application?
For IA number 4 in WP 6586 of 21. For the interim application number 4 of 21 dated 7/12/21.
Take out that application.
Last document.
This file only.
Last.
Yes.
Your Lordship, kindly go through the order path with order court on 27th July, Your Lordship. 27th July, Your Lordship.
You appear for?
There are two orders. I appear for the petition in the first matter.
And after all this, the latest order is on 30/11/2021. After hearing all these issues.
All right, all right. Just let us first understand what he wants to say.
Yes, Your Lordship. 27th is a detailed order passed by this court.
This is Geeta Mishra.
Yes, Your Lordship.
Appearing in this?
27th July, Your Lordship.
Take out the order.
Order in WP number 6586.
Yes.
27th July. Order
You
in
appear
WP.
for whom
Appear
you
for-
appear? Whom you are appearing? For whom
order
you are-
27th
Mr.
July.
Mr. For whom you are appearing, Mr. Mohan?
Petitioner, first matter, Your Lordship.
Petitioner.
Yes, Your
All
Lordship.
right. All right.
27th July.
Yes. 27th July.
Order in WP 6586 of 21, Your Lordship. The first matter.
6586. Yes.
The petition is filed in public interest wherein the challenge is to the order at Annexure B, which is the order dated 11th March 2021, passed by the Commissioner of Police of Bangalore City on the basis of the letter dated 10th March 21, submitted by the 7th respondent in the said writ petition, as well as on the basis of a note dated 10th March 21, issued by the Office of the Honorable Home Minister. The Learned Advocate General represents the first, second, third, fifth, and sixth respondent. The fourth and seventh respondent are also represented before this court. As the challenge in this petition is limited to Annexure B, we direct the first and second respondent to file statement of objection dealing with the said challenge. The Learned Advocate General states that the statement of objection will be filed within a period of 1 week from today. The fourth and seventh respondent have already filed the statement of objection. That has been done, Your Lordship. All the states also. Para 4, Your Lordship. Only as a factual aspect, we may note that here that the order at 11th March as well as the note signed by the Honorable Home Minister do not refer to any specific first information report. So then the court, after hearing this, felt that this matter is required to be heard at length.
Don't know, Lords, what my learned friend is
Yeah,
trying
continue.
to Here, my Lord, the
Let
question.
him say. Let him say what he wants to say. No,
Para 13.
all right. Yes.
Therefore, apart from the issue of legality, para 13, Your Lordship.
Yes.
Apart from the issue of legality and validity of the Constitutional Society, the issue of legality of the investigation carried out in the absence of the head of the city will have to be considered by this court while filing the set of objections. The state government as well as city will have to deal with this aspect. Kindly see, then subsequently another order was passed by this court on 12th August, Your Lordship.
What do you want to show from all this?
No, whether the constitution of SIT is in a proper or not is that has to be heard by this court. Even on 12th August, also this court reiterated that order. At this stage, kindly see the 12th August also, Your Lordship. 12th August, Your Lordship.
Yes.
Para 7. At this stage, the learned para 7, Your Lordship. 12th August.
CLBC.
August, Your Lordship. Para 5, Your Lordship.
Yes.
There are various issues raised in this petition, including the issue of legality and validity of para 5, Your Lordship.
Yes.
There are various issues raised in this petition, including the issue of legality and validity of the order passed by the Honorable Home Minister of Constituting SIT. The issue of locus of the is one of the issues also raised. Therefore, these petitions will have to be heard and disposed of finally. Finally, for that purpose, we direct the petition listed as that the interim order granted sold at this stage, para 7, Your Lordship. At this stage, the learned advocate general said that due to the absence of the head of the SIT, the investigation is not vitiated. This is an issue which will have to be gone into at the time of final hearing. We may note here that the query made by us to the head of the SIT was only with the object of whether there is any effort made by him to ensure that a proper investigation is carried out in his absence. So by this court passed the order, it requests final hearing, Your Lordship, under section 170 CRPC.
What we remember on the last date,
yes,
it was informed that the head of the SIT has joined back.
Please,
but he has not signed.
Now he has approved the investigation report, which
Please,
has
Milord.
been
Please,
done.
Milord. Please, Milord.
Now that ground is no more available to you, that the head of the SIT is not available. He has not seen the investigation. It is without his approval.
No, there is no problem on that point. Now the issue is that whether the constituent SIT has to be heard by this court finally. That is what this court observed in our.
Please don't disturb. You cannot speak simultaneously. Only you can speak one by one.
Yes. Now the constitution very SIT as per Annexure B is valid or not. This court has to go into. That is the only thing which is.
All right, that we will consider.
That is the point. Yes, Your Lord.
Your only objection is that the validity of SIT is to be considered by the court. That
Yes,
is to be done finally. That is to be done finally.
Please,
but now the investigation has been completed.
Yes, Your Lord.
Let the report be submitted before the court concerned. Let the court consider it. Take the cognizance, whatever the court wants. Let the competent court may consider that investigation report. How can we stop it?
No, we are not saying on that point, Your Lordship. Very concept of SIT itself is
At that time,
can they submit a report? Can that report
Mr. Please try to understand. At the time when the interim order was passed,
yes, Your Lordship.
the head of the SIT was not available.
Yes, Your Lordship.
He had not approved the report.
Yes, Your Lordship.
Now the application which has been filed
yes, sir.
by the respondent,
yes.
If you come to that, the affidavit has been sworn by the head of the SIT only.
Yes, sir.
And Somendru Mukherjee, Additional Commissioner of Police.
Yes, Your Lordship. Yes, Your Lordship. Yes, Your Lordship.
Now, therefore, this ground of non-availability of the head of the SIT is no more available.
No more.
The investigation has been completed, report has been submitted in seal cover before the court.
Yes.
That we had seen it last time, as is evident from the order.
Yes, Your Lordship. So
now,
only
thing is whether in view of the interim order, we have to restrain them from submitting it before the court concern or not.
Yes. For that, the constitution of SIT has to be looked into by this court. Because
that question, otherwise also, how can you stop?
Your Lordship, to consider SIT
whether there is SIT or no SIT.
There must be an FIR complaint must be there, Your Lordship. There is no such complaint.
Telling that report before the competent court.
That request
what do you know about it? I don't think we don't think that there's any difficulty in permitting them to.
Would your Lordship permit me to say a few words on? I've filed a petition on behalf of the victim.
The only petitioner counsel was arguing?
No, he is not for the victim, my lord. His is a PIL petition. My petition is a petition on behalf of the victim, my lord. That is, the petition in which they have filed this IA is in my petition, my lord.
Just a minute. Just a minute.
Yeah, I know. I know this. My Lord, I am appearing in writ petition 9803 of 2020.
I got this file.
9803, my Lord.
In this also, you have challenged the same
My Lord, we have challenged, yes, we have challenged the order
order.
of the minister, my Lord, of the minister, whereby he directed the Commissioner of Police to submit a report to himself. My Lord, that your Lordship will find that order at page 25 of the writ petition, my Lord, filed by Geeta Mishra. It is, my Lord, the sequence
So
of
first, let us understand. Now the victim has also come before the court.
Yes, yes, my Lord, yes.
You
And I'm
you have filed a writ petition separately.
No, my Lord, I have filed a writ petition on behalf of the victim.
Victim, yes. Victim
Yes.
has come before the court. This is what we are also saying.
You're right. Your
Now,
Lordship
when
is
the victim is before the court,
Yes.
what is the necessity of this PIL?
Well, that I am not able to make any comments. I have not filed a PIL. That your Lordship may take any view of the
We are
matter.
hearing it all these jointly.
They were,
So earlier, probably when this PIL was filed,
yes,
the victim was not before the court.
that's true, my Lord. That's true.
Now victim is before the court.
That is true, my Lord. That is true. The victim has filed her own petition, being petition number 9803. That's correct, my Lord. The victim has come on record.
Necessity of the PIL anymore.
My Lord, perhaps your Lordship may take a view on that, but I don't want to make any comments.
We just wanted open
Yes.
discussion.
My Lord, yes, my Lord. I have filed an intervention in the PIL, but my Lord, frankly speaking, the issues will be common.
Yes.
There
You're very fair.
Yes, my Lord, the
Thank
issues
you.
are entirely common. Both of us appear to be challenging the order of the minister, whereby
Yes.
he directed the police commissioner to submit a report to himself. So, my Lord, I will be wanting to make submissions at some length. And, my Lord, my first thing is this application has been filed. It is true, my Lord, it is on the record of the court, and I have been served with a copy. But, my Lord, your Lordship have not issued notice on this application as yet. If your Lordship issues a notice, my Lord, I will file a very detailed reply to this. Otherwise, my Lord, it is not possible for me to make submissions without my reply coming on record. So, my Lord, my respectful submission to you would be today, if you issue notice on this application, I will definitely file my reply, and on the date which your Lordship fixes, I will complete my submissions. In fact, I'll file written submissions in advance.
No, Madam Indra Jaising, what we understand.
Yes.
The little understanding of law, what we have got, is that if investigation is done by any higher police officer,
yes,
then that is permissible under CRPC.
Yeah, my Lord, may I just respond?
That is permissible. Let me complete the sentence.
Yeah.
That is permissible under CRPC under section 36. Now, so far as the constitution of SIT and the order passed by the minister concerned, prior to lodging of FIR is concerned, that is the only question which is required to be considered by the court. and that can be considered at the final hearing.
My lord,
Now, so far as the part of investigation is concerned, that investigation, rightly or wrongly, we don't want to make any comment at this stage, and we are not the competent court to make any comment on that. Is to be seen by the competent court. Now investigation has been completed. Let the report be submitted before the competent court. The court may consider it, you may challenge it, you may do whatever is permissible under law. But why shall we restrain the respondent from submitting that report to the competent court at that stage when the interim order was passed? What we understand is that the head of SIT was not available. He had not seen the report. He had not approved it. Now that is not the situation. The head of the SIT has filed affidavit saying that he has approved the report and he may be permitted to file it before the competent court.
Yes, my lord, I have understood. My lord.
And for that, we had called for an application on the last date.
Yes.
That if you want to submit it, make an application.
Yeah, my lord,
now that application is also on record.
My lord, yes. What I'm saying is, my lord, on that application, your lordship have not yet issued notice. I am only saying if your lordship issues notice.
No, you were heard at length.
Yeah,
you were heard at length before, and you are fully aware that what was the observation of the court
let me respond.
and what is the order passed.
Yes,
you are fully aware.
Yes, my lord, I was aware, I was present.
What did you could have filed the objections?
My lord, just hear me. My lord, may I respond to the proposition put to me?
Yes.
Namely, that a higher official can conduct the investigation. My lord, on that I have submissions to make. My lord, with respect, what your lordship is saying ordinarily is true. But in the facts of the present case, my lord, what is the case with which I had come to this court? May I just submit, my lord?
Yes.
My lord, what my lord put to me ordinarily is the position of law under the CRPC. However, my lord, why we had come to this court? We had come to this court with a positive request. And the positive request is that we wanted an SIT set up by this honorable court. Why, my lord? There was a reason for that. The reason for that is because the person who is being investigated or against whom I had made a complaint is a minister in this very government. The very government, my lord, the very home minister who issued that order to the police commissioner is part of the government in which this gentleman was a minister. And therefore, my lord, apprehending bias and according to the rule of law, my lord, the SIT should not have been constituted by him, but should have been constituted by this honorable court. That was my positive case before the court. Now, my lord, I told you they have leaked the report of the conclusion of this investigation in the press that I informed my lord on the last occasion. According to the news reports, I don't have the benefit of the status report, my lord. The status report has come only to this honorable court. But according to the news reports which have been published, which they have not denied, it appears as if this investigating team, I will not call it an SIT also because it was not constituted by this court, has come to the conclusion that there is no merit in her FIR. And my lord, my learned friend has repeatedly said that we want to submit what is known as a closure report. Now, my lord, the state has been changing its stand from time to time before you. So far, my lord, why? Let me explain one thing. Why are the reports coming to this honorable court? Why has this honorable court entertained 4 status reports? Because the understanding has, according to them, the understanding is the SIT is set up by this honorable court. Now, my lord, in the latest application, they have changed their stand on the record and they've said, no. The SIT was not submitted by this honorable, not appointed by this honorable court. It was appointed by the commissioner of police. Now, my lord, how can they change their stand midway? if it is an SIT appointed by this honorable court, my lord, then I'm entitled to submit before you that this is not a proper report. Then your lordship is monitoring the investigation. But point that I'm making is, my lord, if it is a fact that your lordship is monitoring the investigation, then I will have to tell you that the investigation has not been conducted in accordance with law. If your lordship is satisfied that it is conducted in accordance with law, then your lordship can certainly take that step of sending it to the jurisdictional magistrate to take a call on it. And I have my right to file a protest petition. My lord, I agree with that. But that stage has not been reached, my lord. That is my point. The stage has not been reached at which your lordship will send this report to the jurisdictional magistrate. Once that stage is reached, that your lordship is satisfied.
What is that stage?
That stage is as follows. Either your lordship must take a view that this is an SIT constituted by this honorable court. Otherwise, why will the reports come to you, my lord? Why should the status report come to you? If it is an SIT set up by the Commissioner of Police, none of us would be here before you. It goes straight to the jurisdictional magistrate. We would not have been here in this court. We are here in this court, my lord, because the state took a stand that this SIT has been constituted by this honorable court. Therefore, the court said, all right, submit the status reports before us. Now, my lord,
whether the court had restrained them from making investigation?
Not at all. Not at all. My lord, that is not my case. That
investigation was allowed to continue.
My lord, yes, I am
investigation continued. Now investigation has been completed.
That was
the report has been prepared.
Yeah, yes, my lord. But the question before you send it to the jurisdictional magistrate, I will not object at that stage, my lord. Sending to jurisdictional magistrate. Before you send it to the jurisdictional magistrate, my lord, your lordship must be satisfied in law that the persons who conducted the investigation had the authority to conduct it. Now, just, my lord, as a matter of law, there are two separate FIRs. One is filed by the minister and the other is in the Shivaji Nagar police station. The other is filed by the victim in the Kaban Park police station, my lord. Now, my lord, by what authority of law do these two FIRs get merged with each other? I am not aware. There is no provision in the CRPC for merging two different FIRs in relation to two different crimes and having them investigated by one person. My lord, his complaint is...
It is a good ground to challenge it.
No, my lord, but this is my jurisdiction to challenge. My lord, that's the point.
This is not the right forum.
No, my lord, I'm sorry. The magistrate concerned will have no jurisdiction. Once your lordship, my lord, directs this matter to be placed before a magistrate to consider the investigation, my lord, the jurisdiction of the magistrate will be limited to seeing whether or not the investigation makes out a case of an offense and whether to accept the closure report or not to accept the closure report, or whether to direct further investigation under 178. That is the limited jurisdiction of the High Court. The Magistrates Court. My lord, only the High Court has jurisdiction to go to the root of the matter, namely, was this investigation conducted by a person authorized by law? And now, my lord, as I said, let me just explain this. Your lordship, my lord, with your vast and extreme knowledge of criminal law, will be able to enlighten us on this subject. Here is one FIR where the minister is saying this video has been morphed. Simple FIR. He wants an investigation under the Information Technology Act, saying that he's being framed that the video has been morphed. All right, my lord, that may or may not be true. It is not for me to say. It's for the investigating officer to find out. Now come to a completely different issue, my lord. I am a victim of rape. I am saying that I have been raped by a person in authority. I am saying, my lord, that I went to meet the minister. He was willing to offer me a job. And when I went there, I was raped. Now, my lord, my short question before this honorable court, and I will be, my lord, delighted to be enlightened on the subject, is that what they have seemed to have done is, my lord, they seem to have conducted one single investigation by a so-called SIT, presumably constituted by the Commissioner of Police, my lord, and they have come to you with one final report. which deals with two different FIRs, my lord. Now, the question I'm raising is, my lord, is this permissible in law? First of all, my lord,
all right, we have understood. Let the other side hear the other
I
side.
want to submit, I want to make detailed submissions on this. There are judgments of this honorable court which says it cannot be done. And I would like to place all those judgments before you.
All right.
Once that jurisdictional issue is clear, then, my lord, yes, the matter can go before a magistrate, reserving my right to contest it. And, my lord, as I said, they have leaked the information. So what is the situation today, my lord? His FIR is investigated and will go ahead. My FIR, there is a closure report. Why, my lord? Why was the investigation agency allowed to be biased by combining these two FIRs, my lord, and saying even a trial cannot be combined, my lord? There is no provision in law which...
Right, let us hear the other side as to whether the two criminal cases lodged separately, can the investigation be done jointly on that?
Yes.
Yes.
Yeah.
But may I submit on behalf of this SIT? Now, in our application,
just sorry for the interruption. Please, he's calling it an SIT. Please note that. Who set up this SIP? Please kindly clarify, sir.
may I submit?
Your Lordship, one submission, Lordship, before the senior counsel makes. Section 158 CRPC provides for constitution of a submission report by an officer or investigation appointed by the government notification, Lordship. There is no government notification as far as this case is concerned. That is what we have made very clear, Section 158 CRPC. And then again, 173 report also, the superior officer appointed by the government can do it. Government has not constituted any SIT, Lordship. A commissioner.
I agree, my lord. There is no order. There is no order of the state appointing an SIT.
Various statement of this court and Supreme Court.
Well, not only the government has the power to appoint an SIT, the police commissioner has no power. Section 36 does not give power to appoint an SIT. And he is himself calling it an SIT.
That was based on a letter written by the Home Minister.
All this is being done, my lord, only to favor a minister. That's all. A former minister.
You are referring to 156. Are you referring to 156?
158, Your Lordship. 158. That is reflected in 173 CRPC final report also, Your Lordship. 158. 158, 1, Your Lordship. CRPC.
And here the question will be, who is submitting this report?
That's what.
Is it the High Court directing submitting of the report? Is it the police commissioner? Is it an SIT? If it was an SIT, it was set up by whom? By which order of the state?
Investigation has been done pursuant to the lodging of FIR, a criminal case.
No, it has not happened.
No, it is not done pursuant to the lodging.
Investigation is done pursuant to this FIR number 30.
No, wrong, Your Lordship. Kindly see the
permit, my lord, I'll make my submission.
SIT is a separate issue. Investigation is a separate issue. Investigation has been done after lodging of the criminal case.
No, my lord, with great respect, the whole controversy started well before the FIRs were lodged.
All right, that we understand. The SIT was constituted by the police commissioner under the direction of the minister concerned before a criminal case was lodged.
Well, as my learned friend points out, the police commissioner does not have a power under 36 to set up an SIT.
All right. That issue with respect to constitution of SIT is to be considered by the court.
Yes, my lord, yes.
We are not deciding right now. That issue we are not deciding right now.
But the point
we are only on the investigation part of it, and whether that investigation report is to be submitted before the court concerned or not.
Very well. Let me put it this way. Only an investigation report by a person authorized in law can be submitted before the magistrate. Now, my lord, as I said, I cannot raise this issue before the magistrate. The magistrate, once my lord transfers this matter to the magistrate for being considered in a protest petition, then that jurisdiction to conduct the investigation will not be challenged, will not be capable of being challenged by me. That can be challenged only in this honorable court. And that, my lord, is a precondition to the forwarding of this report to the magistrate. If my lord is satisfied that...
Now, kindly please address on how the investigation was not done by the competent officer.
Yes, exactly, my lord. For that, my lord, I'll have to take you to the origin of this problem. If you turn to page 25.
Don't go on the facts.
Then how will I do it?
Argue on the legal issue.
My lord, how do I do it without reference to a minimal amount?
We all understand the facts. We don't want that it is a special case or something, or some hi-fi or some people are involved. It is none of our business.
Lord,
we are not concerned with that.
Lord,
we are totally on this small issue, legal issue, as to how the investigation was not done by the competent officer.
Yes, my lord. So as I pointed out, but my lord, with respect, just a few documents will have to be seen. I won't trouble you with a very heavy record, but if your lordship just sees the actual origin of how this investigation came to take place. It was, my lord, by the order, which is at page 25 of the petition number 6586 of 2021. And although the original is in Kannada, my lord, an English copy has been on the record. And that, my lord, only says it's a letter written by the then Home Minister to, my lord, to the police commissioner saying, please, in this background, it has been said, this is on the request of the minister, not my request, my lord. That's the first point in law. That did I, as a victim, lodge an FIR at this stage, pursuant to which you directed the Constitution, the police commissioner to investigate? No. This is now into his complaint that he is a victim of being framed. And therefore, my lord, whatever view you take of the matter, it is limited only to investigation into the complaint made by him, not the complaint made by me. That's the first point, my lord. And the date itself shows that. And my lord, that also said, you send it to the Home Minister to consider further action. The last sentence is, what do we do about it? So this order is not the constitution of an SIT. That's the first point I'm making. The second point I'm making, my lord, is in law, the commission...
You come to the constitution of SIT every time. We are not on that issue. We are...
Lord, then we need... Well, Lord, in that case, we need an answer to the question, whose investigation is this? Your lordship just heard my learned friend refer to it as an SIT. Who constituted this SIT? Whose report is this?
Do you contradict that the investigation, whatever has been done, is done with respect to the criminal case which was lost?
No, I don't concede it, my lord. I don't concede it. But
no, contradict. We are asking, do you contradict this?
Yes, I'm contradicting it, my lord, because there are two criminal cases, not one. There is one by two different people they're not making the same complaint. One person is making a complaint that I've been raped. Another person is making a complaint that I want an investigation under Information Technology Act because a certain video has been morphed.
Now the investigation has been done pursuant to your lodging of FIR or not?
No, my lord. I lodged an FIR in Kavan Park Police Station. And then in accordance with the CRPC, that investigation must be done in accordance with law under the provisions of the CRPC.
Take out that investigation report. We will just see ourselves whether that is with respect to that FIR or not.
There is an order which clearly says that the investigation is being done pursuant to this particular FIR only.
But who
that I have produced it part of my additional statement of objection. That itself makes it clear.
My lord, how can they? Who authorized it? Only the state government can authorize an SIT.
Permit, my lord,
My lord, the fundamental question is, can the police commissioner constitute an SIT? And if
There
so,
is a-
under what powers?
There is an
Under
independent
what
order.
powers?
That we have understood.
Yes.
Madam, that we have understood.
Let my learned friend answer, my lord, under what power?
Let Mr. Ashok argue
Very
what
good.
he wants.
Lord, your lordship may kindly take my additional statement of objections filed in WP 6586 of 2021.
Sorry?
In WP 6586 of 2021,
What is it?
there is an additional statement of objections.
Just a minute.
No, it's filed on 10th August 21.
10th August.
August.
Additional statement of objection by respond number 4.
9, 8 and 10th August. 12th August.
Yes.
Sir, there at page 21.
Mr. Prasanna Kumar, this has been filed by you on 10th August.
Please, Vinod, please, Vinod.
Dated 9/8.
Please.
Yes, 98. At page 21 of that statement of objection, there is an order passed by the commissioner.
Yes.
Now, this FIR number, this crime number 30/21, my lord, is the FIR registered pursuant to the complaint filed by the victim. May I read that, my lord? Subject entrusting of Kabban Park Police Station case to Special Investigation Team for investigation regarding crime number 30/2021 of Kabban Park Police Station under 67A Act and 506, 504, 376C, 417 IPC. The case registered on the file of Kabban Park Police Station in crime number 30 of 2021 under so and so is ordered to be transferred to the Special Investigation Team for further inquiry on the same issues filed at Kabban Park Police Station, and Srimati MC Kavita, Assistant Commissioner of Police Traffic East, Bangalore City, has been appointed as the investigating officer. Accordingly, Srimati MC Kavita, Assistant Commissioner of Police Traffic East, Bangalore City, is instructed to take the consent file from the IO, Kabban Park Police Station, and to continue the investigation, report the progress of the case to the head of the investigation team in the diary. The Deputy Commissioner of Police Central Division is instructed to supervise the day-to-day progress of the investigation of the case and to guide the investigating officer at every stage. The Police Inspector Kabban Park Police Station is instructed to hand over the transferred file mentioned under reference number to Srimati MC Kavita, ACP Traffic East, Bangalore City. Pursuant to this order, the MC Kavita is the investigating officer that is supervised by the other members of the Special Investigation Team. This has been done after the filing of the FIR registered as FIR crime number 30/2021. Investigation is done pursuant to this in respect of this FIR only. So the question of saying that the Special Investigation Team is constituted earlier, thereafter there is a specific order of transferring the investigation to Special Investigation Team, and a separate officer is appointed as the investigating officer. Now, pursuant to this, investigation is done. Kindly see, one of the offences 376C under section 173 of the CRPC. Wherever offence under 376 is involved, within 2 months I have to complete the investigation. Kindly see 173 subclause 1A. The investigation in relation to an offence under section 376, 376A, A, B, P, C, and so and so, the Indian Penal Code shall be completed within 2 months from the date on which information was recorded by the officer in charge of the police station. Now, after that, under subclause 2, he shall communicate immediately to the magistrate as soon as it is completed. Officer in charge of the police station shall forward to a magistrate empowered to take cognizance of the offence on a police report. A report is the form prescribed by the state government stating so and so. Then at subclause 8 also, subclause 8, it provides for enables further investigation to be done. by the magistrate.
That's crime number or not?
Crime number 30, Lord.
Just a minute.
Crime number 30, FIR is there at page. Page 35, Annexure D. The translated copy at 38. Blood, your lordship. Yeah.
Yes, what do you have to say?
Blood, your lordship
the
are aware that.
Contention. Just a minute.
Yes.
What do you have to say with respect to the contention raised by Madam Indra Jaising that a joint investigation with respect to two separate crime numbers could not have been done?
This crime number, this is only in respect to FIR 30 only. This we are sought for permission only in respect to FIR. There is a separate order in respect to FIR 21.
The SIT, whatever you people say, SIT or other investigating team, they have conducted the investigation with respect to 3 crimes numbers for which separate cases were lodged.
Yes. This
Now,
investigation is only in respect of FIR 30 only. We are not seeking for permission for other FIRs.
the investigation has been jointly done.
No, not page 19 may kindly be seen. No? Page 19 of the
There is a
welcome.
separate order for the other FIR, separate IO is there. Kindly see page 19 of the additional statement of objection. There is a separate IO for the other FIR.
There are separate IOs for separate all the crimes.
Please,
crime numbers.
Yes, so therefore there is a separate investigation.
For that, the investigation has not been completed. That is pending.
Yes, it is still
It is
pending.
only with respect to crime
Only
number
in
30.
respect of 30, yes.
All right.
For the other case, Lord.
And all these different crime numbers, they relate to the same incidents.
Lord, there are some.
Or they are separate incidents.
Yes, separate incidents. Separate incident allegations are different. That is FIR 21 also. For that, there is a separate.
What are the other crimes?
The other case is that FIR 21, Lord, which is at page that FIR is produced.
Page 32.
Page 32.
Annex is the typed copy.
The investigation. And
this is given by the accused in the other case.
You are seeking permission to file this report before the court concerned with respect to the investigation done on crime number 30.
Yes, Lord, only that. The other investigation is still pending.
Respect to this, we want to submit. Yes.
So, Lord, so far as the other FIR 21 is concerned, there is a separate order entrusting investigation to another IO, which is at page 19 of the additional statement of objections.
Yes, for all three crimes, there separate IO is there.
Yes, yes, yes. So therefore, that investigation is not yet over. We are not seeking for any permission only. Only in FIR, the crime
No,
number
the
30.
investigation with respect to 21 is also completed.
21
As,
is not. 21
as per the report which has been submitted before us, the investigation with respect to crime number 61, sorry,
Yes,
61.
But the parents of the child, the victim had filed. That was.
That's a different matter, my lord.
That is complete. 21 is pending.
21 is pending.
Yes. All right. Yes,
Only,
take
the only one last submission is, my lord, your lordships are aware.
Section 173(1). Capital
A. Counsel for the petitioner, as well as
One submission, Lordship, for a moment. Lordship,
Yes.
my learned senior has read section 173 CRPC. In that subclass 3, kindly see your Lordship, because that has to be read together with 158. You are assuming that Commissioner has transferred the investigation crime number 30.
he leave all questions open for the magistrate to consider.
Subclass 3, your Lordship. For a moment, just sorry for the
173, subclause 3.
3, your Lordship.
Where Superior Officer of Police has been appointed under Section 158, the report shall, in any case in which the state government by general or special order so direct, be submitted through that officer, and he may, pending the order of the magistrate, direct the officer in charge of the police station to make further investigation.
No.
Yes.
As per the document additional affidavit filed by the statement of objection, the only Commissioner has done it, not the government. Because that is what we are saying. Annexure A and B also not by the government. So this is the basic thing we are highlighting in this petition. That's all, your Lordship. Please, your Lord. Sorry.
With the Lordship's permission, I do submit that the threshold issue for this court's consideration before transferring it to the
is with respect to constitution of the SIT.
Not just constitution. Yes, not just. First of all, Lord, we need clarity. If my learned friend can clarify, he repeatedly referred to it as an SIT. Is it or is it not? First point. Second, or is it an investigation under 173 and not by an SIT? If it was an investigation by the relevant investigating officer under the CRPC, why did this court ask Sumendra Mukherjee to look at it once again? There is no need. There is no need, my lord. Then if you're following, my lord, what I'm saying is this: either we strictly follow the CRPC, or, my lord, this court has the power to set up its own SIT. And then we go according to the procedure prescribed by law by this honorable court for the setting up of an SIT. Or, my lord, the third option is the state sets up an SIT. Now, in this case, none of these three has happened. Neither has the state set up an SIT, nor has this court set up an SIT, nor has the procedure prescribed by law under the criminal procedure code been followed. Now, my lord, if your lordship is inclined, I will say one last thing, my lord, and I leave it to my lord to decide. I only want two simple submissions to make. One is just give me the liberty to file my written submissions. Your lordship may pass any order. Secondly, after reading them. And secondly, my lord, will I be at liberty to raise the question that the investigating SIT had no jurisdiction to investigate in the light of the submissions which I'm making before this honorable court? Or, my lord, will the magistrate be bound only to look at the actual investigation?
We will We will leave all the questions open to be considered by the magistrate
By the jurisdictional magistrate.
with respect to even the jurisdiction of the investigating agency.
But the jurisdictional
All right.
magistrate, the jurisdictional magistrate in this case, my lord, will be the Kaban Park. The magistrate.
We are not answering that to you.
No, my lord, because then if it is submitted to the wrong jurisdictional magistrate, what are we going to do?
That you all raise all those questions before.
And then, my lord, this entire petition will become infructuous. Once this matter.
No, we will decide the issue with respect to constitution of SIT. Validity
At what stage, my lord? I am submitting it's a threshold issue.
After exchange of affidavits, everything.
It has been done. All exchange of affidavits is complete. And my written submissions are available with me. I'll just file them. That's all.
All right. You file it.
Yeah, then your lordship may pass the order after reading the written submissions, my lord.
No. Let us first decide this application. Then
what is the point of filing my submissions if your lordship are not going to read it?
That is on the main relief.
But my lord, without the main relief, the interim relief cannot be passed. It's a precondition, my lord.
All right, we have considered your submission. Yes, heard. So, counsel for petitioner as well as Mrs. Indra Jaising, Learned counsel for the petitioner victim in connected writ petition such and such, as also the learned advocate general appearing for the state, and Mr. Ashok Nadi, senior advocate, appearing for the respondent.
Number 4, please.
Number 4.
Number 4. The counsel for petitioner submits. The submissions have been made. Submissions have been made basically on the application preferred by the respondent, number 4, for permitting them to submit the investigation report in relation to the case crime number 30 of 2021, registered at PS Kabban Park, Bengaluru, to the court which is competent to take cognizance of the offense in the ends of justice. Learned counsel for the petitioner as well as Mr. Indra Jaising, learned counsel for the victim, have submitted that the investigation has been done by the so-called SIT, which was not constituted by the state government or this court, and the entire investigation has been done without competence and jurisdiction. The so-called SIT was constituted even prior to lodging of criminal case number 30 of 21, and as such, the investigation cannot be said to have been done with respect to that crime number. It is submitted that in the special facts and circumstances of this case, the court had monitored the investigation, and unless and until the question of validity of the constitution of the SIT is determined it would not be proper for allowing the application and permitting the respondent to submit the investigation report before the competent magistrate. First off, the learned counsel for the respondent number 4, on the other hand, submits that the police commissioner, by order dated 29th of March 2021, had entrusted the investigation of crime number 30 of 21, E.S. Kabbanpar, to the special investigation team, and Srimati M.C. Kavita, Assistant Commissioner of Police, Traffic East, was appointed as investigating officer. The investigating officer has completed the police investigation and submitted the report to the Additional Commissioner of Police, West Bangalore, Mr. Soumendra Mukherjee, who was appointed head of the SIT. He has approved the said report and after its acceptance has made this application for permission to file it before the competent magistrate court. The submission is that there is no infirmity or illegality in the investigation conducted with respect to crime number 30 of 21. The IO appointed by the police commissioner is a senior police officer of the rank of assistant commissioner of police, and she has conducted the investigation and prepared the investigation report, which requires to be submitted to the court concerned, to the competent court concerned. Full stop. It is further submitted that the investigation with respect to case crime number 21 or 21 is still pending, whereas the investigation with respect to crime number 61 of 21 under section 363, 368, 343, 346, 354, 354 bracket में small a, 506 IPC has been completed and a B report has been submitted on 18/5/2021. It is also submitted by learned counsel for the respondent that under the provisions under section 173 CRPC. The investigation with respect to crime relating to section 376 376A, AB, B, C, D, DA, BD, and E, IPC are to be completed within 2 months from the date on which the information was recorded by the officer in charge of the police station. As such, it was necessary in the present case to complete the investigation and submit the investigation report, as the allegations as per the FIR with respect to crime number 30 of 21 are relating to offenses under section 376 and 376C. Full stop. Considering the learned Advocate General appearing for the state submits that this court had granted the interim order considering the material fact that the investigation was being conducted by SIT. However, the head of the SIT was not available as he had gone on long leave. The court had restrained the filing of the investigation report, but had not stopped the investigation to be carried out by the SIT. Full stop. We have considered the submissions made by parties counsel and gone through the record. The question with respect to the constitution of SIT under the impugned orders and the validity of the said SIT is to be considered by this court. So far as the permission to submit the investigation report in relation to crime number 30 of 2021 is concerned, we are of prima facie view that once the investigation has been completed and it has been duly accepted and approved by the head of the SIT, there is no reason for us to restrain the respondent from submitting it before the concerning competent magistrate court. As such, leaving all the questions open for the learned magistrate concerned, including the question of competence and jurisdiction of the investigating agency oblique officer, investigating agency oblique investigating officer. We permit the respondent to submit the investigation report in case crime number 30 of 2021, PS Kabban Park, Bengaluru, before the magistrate concerned. With this, the application stand disposed of. This is the case. Give it after 4 weeks.
Well, Lord,
The-
kindly grant permission to file the written submissions for your lordship and put it on record. The registered
Madam Indra Jaising wants to file the written submissions. She is permitted to do so.
Obliged, ma'am.
The report submitted by the SIT in seal cover is perused. The report shall be again put in seal cover.
Application there was an interest by some other person in the court proceedings filed. There was order to the effect that it was issued. So there is an affidavit by him.
Madam Indra Jaising, on the last date, there was some interruption in the proceedings.
Yes, ma'am.
by some intruder
Yes, ma'am.
Against whom the notices were issued.
Yes, ma'am.
And now he has submitted his affidavit.
Yes.
Apology. What affidavit has been submitted?
Unconditional apology.
Unconditional apology. He has submitted unconditional apologies.
Yes, ma'am.
So what you
My lord, I have no.
whether we should proceed against him or we should drop
No,
the
no, my lord, no. I have no objection. His apology, as far as I'm concerned, may be accepted. It could have been a genuine error. I cannot say. I don't want any further proceedings. I leave it to my lords to decide.
All right. On this, right. Write a separate order. The court, by order dated such and such, had issued notice. Is that order? To Siddharth Bhatia.
Sridhara N. Bhatta.
Sridhara N. Bhatta, who had interrupted the court proceedings and appeared before the court without proper dress. Pursuant to the notice, Mr. Sridhar Bhatta has tendered his unconditional apology on an affidavit dated 1/1/2022. It is submitted that his act was unintentional and he is extremely sorry for the inconvenience caused to all the participants. It is submitted that he has realized his mistake and undertakes that he will not commit any such mistake in future. Full stop, para. Considering the unconditional apology on affidavit submitted by Shihar and Bhatta, we drop the proceedings against him at this stage. And however, with the observation that Mr. Bhatta shall be careful in future.
We filed the contempt.
9th March.
Obliged.
Number 10.
I beg to appear for the petitioner's counsel, my lords. My lords, your lordships would recall prayers A and B in this petition, my lords, were not satisfactory. We have made an application IA3, my lords, to amend prayers A and B, my lords.
IA3.
Please. Mandamus was sought, my lords, when certiorari should have been sought.
Last document.
Yes, who appear for respondent?
Your lordships are yet to issue notice.
Number 2.
We will allow the amendment application.
I have no objections, ma'am. I have no objections.
Heard. Mr. Adit, then senior advocate, assisted by so and so, on IA number 3 of 2022. Counsel for the petitioner applicant submits that inadvertently by mistake proper prayer was not made in the writ petition. He may be permitted to amend the writ petition in the manner as has been proposed in the application. Full stop. The application is allowed. The petitioner applicant is permitted to carry out the necessary amendment in the body of the writ petition and within 1 week and file the amended copy of the writ petition. Give it after 1 week.
Lords, may I make a submission? Lords, there is a challenge, my lords, to the auction notice in this case, and the date for auction is the 10th. Therefore, lordships may kindly permit me to submit, my lords, on the interim play that we have sought.
First,
Challenge, my lords.
let the petition be first maintainable, only then anything can be done.
Lords,
Today is 3rd. We'll have it next week before 10th.
Your lordships, kindly consider, my lords, my submission today, my lords, if convenient to your lordships.
No, it is not possible, Mr. You understand, unless the writ petition is maintainable. Now, when you will incorporate the amendment, only then it will become maintainable. Otherwise, the manner in which it is here today.
I quite see. Your lordships then have it on Monday, my lords, because the auction date, unless my friend can submit that no precipitate action will be taken till.
All right, we'll take up on 8th.
Please. Please.
Number 11. Chandranath Tariga.
My lord, may I please your worship? This, my lord, writ petition, writ seeking mandamus that was disposed of by annexure A, my lord. Would your lordship now kindly turn to annexure A at
It's a review.
It's a review petition for this reason. Page 17, paragraph 2 may kindly be seen. So and so, for the respondent submits that the petitioner has already filed a revision application in RC 13/3/2020.
Yes, what is the ground of review?
Review is such a review application, revision application is not in respect of the matter which was before my lords on that day. My lord, the revision application is also placed before the court at annexure B. That is a revision application in respect of seeking extension of the lease, my lord. What was sought in the writ petition is a mandamus to consider the application that the particular leased area was not surveyed. Therefore, he should be permitted to mine the area. That was the petition, main petition.
Mr. Mahendra.
Lord, the last may kindly prayer. Lord, the prayer made in the revision petition is for the extension of lease. Extension of lease, it's a comprehensive revision petition filed before the revisional authority. Lord, bypassing that revisional authority, Lord, he has made certain representation to be considered by the authorities. He could make such application in the pending revision petition itself. Your Lordship may kindly peruse the prayer made in the writ petition.
Yes.
Writ petition is seeking the same relief for resumption of lease.
Lord, that is not so. Would your lordship kindly see the...
May I draw your lordship's kind attention to the prayers?
Whether is the revision and also the writ petition relates to the same land for which the lease was granted in his favor earlier.
Yes, it is pertaining to the same lease.
Then
Lord, may I,
in the very lease, in respect of the very lease, Lord, he made two representation. In the writ petition, he is seeking to consider those two representation. The second prayer is that, Lord, he is seeking
permission
to carry on business of registered ML number so and so. It is one and the same.
Yes, Mr.
That is not so, Lord. Would your lordship kindly see the writ petition prayer or annexure E1 in the writ petition, which is the information submitted that in respect of my lease survey number 316 is not measured. My lord, there is a clear statement by the authorities.
Survey number 326, not.
My lord, the survey number 326.
Yes.
Would your lordship kindly see the writ petition?
Mr. Please, Mr. Ariga.
Yes, my lord.
Thing is that you were granted a lease with respect to one land.
Yes.
At survey number 326.
Yes.
Now, relating to that, you have already preferred revision and that is pending. Now, instead of making any representation or any application in that pending revision, you made a separate representation to the authorities. And now you come up before the writ court saying that your representation may be directed to be considered. And in the meantime, you may be permitted to carry on your business of lease activities. Now, the subject matter is one and the same for which the revision was pending.
My lord,
how this relief would have been granted during pendency of the revision?
Yes.
And what is wrong in this order if we have taken this view?
I'll make my submissions on this, my lord. May I make this submission, my lord? In the writ petition, I have brought to the notice of this honorable court that what was granted to me was survey number 326 of 326 of Janikunta village. That area was not measured nor surveyed. Therefore, when I sought information from the authorities, they themselves admit that your area was not surveyed. Therefore, I gave a representation to the authorities that I may be permitted to mine that area. That is clearly stated in my 2 applications, and that was not considered. No order is passed. Therefore, I was before this honorable court in the writ petition. My lord, the learned government advocate made a submission.
Why can't you make a representation in your pending revision?
My lord, if the court passes an order that representation also shall be considered by the authorities, then it can be done. Otherwise, authorities will not permit me to do that.
This is what they have observed. The grievance, if any, of the petitioner can always be agitated in the said revision application.
My lord, that revision application. My lord, that revision application is only for extension of lease because of section 8. Unless this is considered that what was given to me and what was surveyed are 2 different areas, and that is considered by the authorities on their own statement.
Mr. Mahendra, whether his representation 21/5/19 can be considered there in the pending revision or not?
No, the jurisdiction of the revisional authority is restricted to the Lord order passed, impugned order therein, Lord.
Oh, you
And
right now
so far as
representation can be preferred in the pending revision.
Lord, my submission is, so far as the dispute with regard to the boundaries are concerned, Lord, there is a separate suit pending which is pleaded in the revision petition. There is a separate suit pending. They have filed a suit.
The representation is with respect to the boundaries.
He is seeking, Lord, the representation is, Lord, may I draw your lordship's kind attention to the representation made in the writ petition. Representations are produced at the annexures. Annexure H, 27/9/2021.
Yeah, hey, what is that?
We don't have the writ petition before us, Mr. Mahendra.
That is for the representation dated 27/9/2021 is in respect of review of the suspension order.
No, my lord, kindly see that is not correct.
I am reading the subject of Annexure H, request for direction so and so, directing the authority to revoke suspension of mining operation, production, dispatch, etc. This is in respect of revocation of suspension order. There, Lord, before the revisional authority, Lord, he is seeking for deemed extension. And further, Lord, annexure, one more representation at
Mr.
annexure.
Mahendra, the question of the Honorable Chief Justice was whether annexure G and H can be considered in the revisional petition pending.
Yes, Lord, it can be considered because both are with respect to the
dispose of this.
Yes, Lord.
Heard, Learned Counsel for the review petitioner, as well as Mr. S.S. Mahendra, who had appeared for respondent in the writ petition. First of, this review petition arises out of the order dated 10th of January 2022. Para. The counsel for petitioner submits that in fact the representations dated 21/5/2019 and 27/9/2021 for which a mandamus was sought in the writ petition are relating to revocation of suspension order whereas the revision application RC 13/3/2020-RC-1 filed by the petitioner is with regard to the extension.
Yes, my lord. Yes.
With regard to the refusal of extension of lease period. We have considered submission. Mr. S.S. Mahendra, Learned Counsel for the Learned AGA, Counsel for Respondent submits that the representations dated 21/5/2019 and 27/9/2021 of the petitioner relates to the same lease for which the said review application, revision application is pending, and as such, the said representations can be considered by the revision authority in case a direction is issued. Full stop. In view of above, we do not find any infirmity or illegality in the view taken by the court in the order under review. There is no prima facie error apparent on the face of the record. The review petition as such is disposed of.
Let the petitioner makes an application requesting the revisional authority, my lord, so that.
Yeah, we have made the observation.
Yes.
Okay, क्या दाखिल करा देगा?
Number 12, Ankita Ji Shilke.
Lord, I appear for the petition.
Yes.
Lord, this is with regard to the validity of the notification issued by the state government demanding.
What happened with the apex code?
My Lord, as far as the District Mineral Foundation challenge made thereto is concerned, the Supreme Court has upheld the.
Stay कर दिया. Further proceeding उसके बाद क्या होगा? Accordingly disposed. Once the transfer petitions were disposed of.
No, I understand, my lord. As far as DMF is concerned, my lord, I may not have anything more to say because the Apex Court has already upheld the validity of the notification. But as far as NMET, that is National Mineral Exploration Trust is concerned, and the contribution to be made by the lessee who holds a mining lease or a prospecting lease is concerned, that could not have been demanded with retrospective effect as has been done by the state government.
Please place the Supreme Court judgment on record. So we'll have to see what has happened.
I do not have a copy of the judgment that's supposed to be.
Have to get it.
It will be available on the net.
You will have to get it to place it on record.
Our matter has been listed today on account of the disposal of the transfer petition by the Apex Court. Shri Pramod Katavi, learned senior counsel appearing for the petitioner, submits that the Honorable Apex Court has also disposed of the proceedings pending before it in writ petition civil number 12027 of 2015. He seeks for a short accommodation to place the judgment of the Apex Court before this court. Released after 2 weeks.
Yes, my lord. I may not have any dispute with regard to District Mineral Fund, but only with regard to NMET. That's the only reason I'm.
We'll see the judgment and then take up the matter, Mr. Katavi.
Very well, very well. A couple of, my lord, sir, please to grant me 2 weeks, my lord.
Yes.
Much obliged.
Second March. Serial number 13.
Serial number 13, I appear for respondent number 1, my lord.
Your Lordship.
On the last hearing, my lords, I had sought 2 weeks time to file objections. My lords, I request for further 1 week time, my lords, I'll have it filed, my lords.
1 week. Counsel for response number 1 is further allowed. 1 week further time to file statement of objection. Give it date. After 3 weeks.
4-3.
Lord, I appear for the state, Lord.
My lord, I have one submission, my lord, in serial number 14.
Yes.
My lord, the matter is pending before the Honorable Supreme Court, my lord, in SLP number 019349 of 2021. My lord, this matter went up to the Supreme Court because my name has been removed by this Honorable Court, and this matter is now suo motu, my lord. But my name is appearing in the cost list. That is the reason why I appear before your lordship. But I would like to inform your lordship that the order I have challenged before the Honorable Supreme Court, and because there is no regular sitting in the Supreme Court, the matter has not yet come up. I request your lordship to have this matter after 15th of March, my lords, that the order from the Supreme Court will.
Yes.
Lord, we were to file the status report, Lord. We have filed it, Lord, today. Your Lordship may kindly.
Learned AG informs that a status report has been filed today in the registry.
Please.
The office may trace the same and place it on record. Give a date after 15 March.
33.
Please.
Grateful.
Appear for the petitioners in this case, my lord.
Yes.
My lords, I appear for the petitioner in this case. In this petition, my lords, the petitioners have questioned the virus of section 5(2) of the Hindu Succession Act, whereby, my lords, the act is not made applicable to certain properties. My lords, before we proceed further, I would like to state a few brief facts for a better understanding of the case, my lords. My lord, the first petitioner is the son of, my lords, one Maharaja Yashwantrao Ghorpade.
To be heard finally today.
Yes. No, not to be heard finally, my lords. What I filed is a application for vacating stay. No, what's happened, my lords? I filed a suit for partition in a civil court in Bangalore.
Whether a statement of objection has been filed.
Not been filed by the Indian government. It's not been filed.
But I represent the second
my lords,
respondent.
today I'll only confine myself for the vacating stay, my lords, because the suit filed by me has been stayed by this court, my lords. Further proceedings have been stayed by this court.
You appear for petitioner or?
And for the petitioner, my lords, in my suit, my lords, in my petition.
Vacating the stay would in effect decide the matter.
Well, the stay is against further proceedings in the suit.
The
So what's
suit,
happened, my lords?
Going to be considered in view of 5(2) of the Hindu Succession Act.
Kindly permit me to.
So until 5(2) is decided, the question of 7 Rule 11 being decided would not arise.
That has been stayed, my lords. In fact, what happened was the respondent filed application under 7 Rule 11. That has been stayed by this court.
Yes, so the further proceedings have been stayed because that.
No, not in that. My lords, what happened was the application.
We will decide finally. No, mister, we will decide finally. Let the statement of objection be filed by the respondent.
My lords, I have no issues regarding, kindly permit me, my lords, to submit, my lords. Kindly, I request. Because from 2 years, my suit has been languishing in the court. That's what I'm saying, my lords. I'm not telling my lords to decide this petition right now. My only prayer is, my lords, the further proceedings may be vacated.
Court
I represent the second respondent.
Yes, Mr. Rajendra, when will you file your objections?
Plus, objections we have already filed.
State has to
If
file.
the virus is under challenge, the state will have to file their objection.
The government
Union
has to file.
Union of India.
Yes, they have to file. One, Mr. My lords, Vinod Kumar has been served. He has to file his objections. My lords, in the meanwhile, what I'm suggesting is, my lords, let the proceedings go on before the court below, my lords. Let the final order not be pronounced. Let the proceedings go on, my lords. This should not be stayed like that. Trial is stayed.
That is not possible. That will prejudice.
My lords, I'm
That
only
is the
saying
precise
let the
reason
trial
why
continue.
after hearing both parties, my lords, this honorable court.
There is a well-reasoned order which has been passed. If you agree by it, you can challenge it.
Yes.
Which order, my lords? The interim order.
16.320.
My lords, that order, my lords, in my petition, my suit has been
Let
stayed.
a statement of objection be filed on behalf of respondent number 1 within 3 weeks.
Kindly fix a date, my lords. A date may be fixed, my lords, please.
Just have patience.
33. You are 16.
Please, my lord, for the petitioner,
I appeal for the states. My lord, statement of objections have been filed. Copy is also served on the other side yesterday, my lord.
Lord, last night the copy was served on me. Lordship, my lord, kindly give me some time to file a rejoinder.
And counsel
May I make a submission in
principal
this,
is
my
allowed 2 weeks time to file rejoinder.
Interim order may
make a
kindly be
submission in this. My lord, I filed my memo of retirement for second respondent, fourth respondent, my lord, on 4/11/2020. My lord,
My
that
lords, I
memo
have
is
one
not
submission to
yet-
make. My lord, this matter could be disposed of. This matter pertains to, my lords, Asiatic building, that is Janata building situated in KG Road. My lord, the state will not, my lords, demolish
Let him
this.
file the rejoinder, will consider.
Obliged.
Lord, interim order may kindly be extended.
Interim order file shall continue till next day.
Obliged. 33.
I appear for the respondent in this matter.
Yes. I am appearing for petitioner, my lord, that I have subsequent events, I have received some documents, my lord. I have got translated, my lord, and there are 3 Supreme Court judgments that I have to file, my lord. Maybe 2 days may be granted, my lord.
My
That's
preliminary objection is that, my lord, the impugned orders are passed by the senior geologist. There is an alternative remedy, my lord, statutory remedy provided.
That, my lord, insofar as, my lord, the cancellation of notification without issuing a notice, and, my lord, by making false allegation saying that, my lord, there is some illegal, my lord, after notification, but they have to formally, my lord, executed lease deed in favor of me, and
No.
without providing
incorrect, my
opportunity.
lord. That is incorrect.
I'll therefore, my lord,
notification, he has
I'll
conducted
kindly see, my
illegal
lord,
mining
kindly see, my
that
lord,
resulted
order.
in death of 2 persons. We
Let
have
the
lodged-
last date of hearing my learned friend sought
have
time for
lodged-
filing statement of objection. If he is not filing, my lord, I'll place, my lord, all the orders of this court and Supreme Court before this court.
All right,
Kindly-
all right. To grant you time, Mr. Ganpati.
Please, my lord, please.
On the request of counsel for petitioner, case is adjourned today to enable him to file certain documents in support of his submissions. Give a date.
I'm sorry, my lord.
Yes, next.
Number 18, Dr. KB Vijay Kumar, 14%.
For the,
Lord, in this case, I appeal for the respondent number 1.
I appeal for the state, my lord. For the petitioner?
KB Vijay Kumar.
None response for the petitioner. Agent, give a date.
12-4.
Next.
Number 19, Kalimullah Sharif.
I appear for petitioner, my lord.
I appear for respondent, my lord. On the last occasion, we filed a memo along with an endorsement rejecting the application of the petitioner. Therefore, this petition may not survive for consideration.
Yes, what do you say, petitioner?
I have received the memo, my lord. I have received the memo and endorsement, my lord, through government advocate, my lord.
He says that lease
In view
cannot
of
be
judgment, it may not
extended
survive,
beyond
my lord.
20. He says lease period
Yes, my
cannot
lord.
be
Yes, my lord. Yes, yes.
So
Yes,
what
my
do you
lord.
say
They
on
have issued an
how the-
endorsement, my lord.
You want liberty, Mr. Sharif?
Okay.
I'm not liberty, my lord. I may challenge that petition, my lord. Your endorsement, my lord.
This petition is dismissed.
I may be given liberty to challenge that endorsement, my lord.
The petition has been filed seeking following relief. Learned AG appearing for respondents. Submit that lease period cannot be extended beyond 20 years as contemplated under Karnataka Minor Mineral Concession Rules 1994. In the present case, the period of 20 years has expired. As such, no relief can be granted. The writ petition is accordingly dismissed. The counsel petitioner does not dispute the aforesaid facts. The writ petition is accordingly dismissed. However, with liberty to petitioner to avail the legal remedy, if any, available to him.
Number 20.
For the state.
My lords, in this matter, there were three directions, my lords. One direction on 13/2/2020. A survey of all hostels was to be conducted by the state government. On 13/2/2020, there is an order, my lords. Another two directions, my lords, was to conduct the inquiry. On 15/1/2021, two more directions were issued by this honorable court, my lords. This is in respect of 5 students who died due to electrocution, my lords, while they were asked to hoist a flag on Independence Day.
What do you say, respondent?
My lords, inquiry report, my lords, is made over in sealed cover. The only aspect, my lords, is I am yet to get instructions regarding whether the money is dispersed. I believe we had, my lords, from our office, we had informed the respondents to disperse the money immediately. My lords, on next date, I'll
affidavit that money has been dispersed.
Please, my lords, I'll ascertain, my lords, and
There was also
to file an affidavit to the effect that the amount of compensation has been disbursed to the victims.
There was also a direction, my lords, on 13/2/2020.
KPTCL?
Yes, my lords.
My lord, KPTCL, my lord, has shifted the line, my lord. I have filed a report today. He filed the report today, my lord, pointing out, my lord, that this line, my lord, has been shifted.
The whole of the state, Mr. Sriranga?
Lord, in the whole of the state, different ESCOMs are there, 5 ESCOMs are there, my lord. They have identified all cases where the level in the vicinity of school, Lord, that process is on. The process of shifting, my lord, by different ESCOMs is on. But
how long will it take? How long will it take?
Lord, it may take another 3 or 4 months, my lord, to the process, because in each ESCOM, my lord, between 1,000 to 5,000 such cases have been identified.
The KPTCL submit that given a period of 3 months, all the electricity lines on or near the schools and hostels would be shifted by the KPTCL as also by the ESCOMs concerned.
My lords, on 30th October 2019, this honorable court had directed, my lords, the state to conduct a survey of all government-run hostels and file a report. Since it was not done, again, my lords, on 13/2/2020, this honorable court, my lords, had directed the state government to conduct survey of all hostels as directed on 30th October 2019 and file an affidavit along with the status report. This has also not been done. They were supposed to conduct a survey, my lords. Since we had filed, my lords, that all the government-run hostels are in a very dilapidated state. Most of them do not have toilets. They do not have drinking water facilities. My lords, there are girls' hostels which do not have bathrooms and toilets.
So Rashika, when will you file that?
Another 4 weeks, my lords. I will do it. Another 4 weeks.
AGA seeks for another 4 weeks time to positively file a report as regard the status of the hostels after conducting a survey. It is made 4 weeks time is granted. It's made clear that no further adjournment will be granted.
It's 11-3. Number 21. Here, Mohan.
Your Lordship, appear for the petitioner. The previous order, this court directed the BBMP to pertain to the Vishwavati River regeneration. And there is an order passed by this court on 19th July, Your Lordship.
You were required to file an affidavit.
For the BBMP in this matter, Lordship, the counsel who is appearing for the BBMP is not well, Lordship. He is under the quarantine. I may be permitted 2 weeks time to file an affidavit, Lordship.
General Counsel for BBMP. Place for the doubt, 2 weeks further time to file the affidavit with respect to the progress made pursuant to the recommendations of NERI. Give it.
And one submission, Lordship. On 112, Police and Control Board has already filed the affidavit of report.
Let
Let
the report of BBMP be filed, then we consider.
Please, Lordship. Date, Your Lordship.
2nd March. 2nd March.
22 March.
Motor repetition.
I beg to appear for respondent number 6 in this matter, my lord.
Repeat respondent. But in this matter, in terms of direction, my lords, the rules are my lords produced this morning, and the my lords directions have been complied, my lords. It is e-gazetted, and the rules which have been e-gazetted is placed on record. Only thing.
Where is that?
You filed it today morning, Mr. Rajshekar.
Today, my lords, today the
And it can't come on record if you filed it in the morning.
He knows it. The date is fixed. Everything is there. It was in his knowledge. On the last date also, he informed that rules have been formulated. Now, thereafter, nothing is done.
Well, these rules were given to the office there. 1 week, my lords, I was on quarantine. At that time, my lords, the rules were given there. I located it yesterday after my matter got listed, my lords, and I have done it today. That was the.
We will start imposing cost for the delay you will cause. That necessary rules have already been formulated, written. And they would be e-gazetted during course of this week. This is what he said on 3/1. It proceeds for a week time to place this rules on the record. Now still the rules have not been gazetted.
Gazetted. Yes, filed it today.
Pass the order.
Then CH Rajshekar Law and AGA submit that the e-gazetted rules have been e-filed today. Registry to place the same on record. Released next week.
Number 23.
My lord, appearing for petitioner in this matter, my lord. My lord, a petitioner has filed this public interest litigation, pointing out the illegalities committed by the respondents, my lordship, where they could have impounded the sale deeds, my lordship, which has been executed on 100 rupees sale deed, my lord. Kindly take it to page number 17, my lord. A sale deed of property has been taken place at 100 rupees sale.
Connection. New connections and respondent not to issue trade license.
They are.
Page 8. Page 8.
It is they are defrauding the government exchequer, my lordship. In fact, they should have paid a stamp duty worth of.
Everything done. Trade licenses, electric connection.
Who are you?
My lord, I'm a practicing advocate, my lord, in Supreme Court, my lordship.
Rajneesh Kumar.
Ranjit Kumar, my lord.
Ranjit Kumar. Where have you given your credentials?
My lord, it is, I have mentioned that my lord, page number 5, my lord, para number 5, page number 6, my lord.
You have to make a declaration as per the rules. Where is
My lord, I have filed this petition as per the rules, my lordship. This is the exactly what it. Para number 5 in the rules, para number 5, I have to state my this one, my lordship. I have stated my background, my lordship.
you should notice the note. Appears for respondent.
Not ordered.
A notice not yet ordered, my lordship.
So notice to respondent. Is there any counsel for respondents?
My lordship, it is the one Shahbaz Hussain appears for this one, my lord. Shahbaz.
For which respondent?
For HESCOM, my lordship. For
There's notice for respondent number 1 and 2. Shahbaz appears for HESCOM.
Yes, my lordship.
That counsel for the petitioner is permitted to serve the counsel for standing counsel Shri Shahbaz Hussain for respondent number 3 and 4. What about 5?
5, my lordship, Sriranga, my lordship.
No, not Mr. Sriranga. Now a senior
Karnataka election. Karnataka.
He's a senior counsel now, Mr. Medicine.
Sorry, my lordship.
I'll check my
KERC, my lord, BN Prakash appears normally.
Shri BN Prakash for respondent number 5. 6-7 government advocate. Issue notice to respondent number 8.
My lord, I have sought the interim order, my lordship. Meanwhile, the respondent number 3 and 4 not to grant new connections, my lordship. Please, my lord.
11th March.
Please.
Number 24. Aparna Bodole.
My lords, appearing for petitioner, my lords. My lords, on the last date of hearing, the question my lords had posed to me was whether Rule 8, the rejection order, the revision authority's order was that the area was not notified. Therefore, the application is not maintainable, my lords. In terms of that, my lords, on the next day itself, I have filed one application before the senior geologist Kolar to verify whether the application was notified or not. That is on 28th of January, my lords. I'm still awaiting the reply on that RTI application, my lords. If the area is not notified, my lords, then my arguments will be different, considering the fact that this 8A1 was omitted prior to the rejection order, my lords. So, my lords, I request for a week's time for me to submit the reply which I may receive from the senior geologist Kolar, my lords. I filed it on the next day itself, my lords.
You had sought time to produce some decision, if any, on similar issue.
Please, my lord, that also I have produced, my lord.
Not RTI. We never asked you for any RTI.
Judgments also, my lords. Judgments also I have produced, my lords. The judgments what I have produced pertains to the fact whether the my lords, the rejection order is dated 18/11/2016. This 8A rule was amended on 12/8/2016, my lords. So, my lords, on the date of the rejection order, this rule was not in existence, my lords. And the pertaining to that, I have produced the Hindstone
So,
judgment.
Mahendra, has this been dealt with by this court?
Yes, my lord. This is a very simple case, my lord, wherein
Application is of the year 2009. Rejection is subsequent to the amendment came into force. That is 12/8/2016.
Not a saved application.
Not a saved application. And after lapse of 3 years, Lord, from the date of rejection, they have referred revision. Revision is belated. On that ground, revision was rejected. In order to substantiate that, Lord, what they submitted on the last occasion is that this rejection order was not communicated, for which this your Lordship was pleased to direct the council to produce certain documents, which they have produced. Even in the revision, they do not plead that it has not been served. All that they say is the reason for rejection, that your Lordship, may I draw your Lordship's kind attention to the revision petition produced.
We'll have to dismiss it.
My lords, this aspect has been considered on the last date of hearing, my lords. I have brought to the knowledge of this honorable court that I have taken that specific contention in the revision application that the area was not, I was not communicated. That has also been recorded in the impugn order, my lords. That, my lords, may come to page number 23, my lords.
Yes.
With respect, my lords, the second paragraph, with respect to this application, although no objection certificate has been received by the office of the senior geologist on 1710, without giving any information, the senior geologist and the competent authority has rejected the application under Rule 8B1 to 8B2B of the Karnataka Mineral Concession Rules. Then, my lords, I have filed the memo for production of document. In that, I have enclosed the application which I filed before the revision authority, my lords. My document is filed on 20th of January 2022, my lords. This is an RTI I obtained where I have said that deputy, it is, my lords, in the form of a form. It is a form where I cannot give a detailed explanation, but I have mentioned it that the deputy conservator Kolar in this letter dated has reported not to issue no objections as damage will be caused to the plant and the forest if explosives are used in the said area, but the said fact is not intimated to the applicant. Hence, requested to allow the revision by instructing the senior geologist. Said fact was not informed to the applicant, my lords. Then, my lords, I have also produced the registrar which has been given on pursuant to the RTI, my lords, where the senior geologists have responded stating that the document was sent through regular post and not through registered post acknowledgement due, my lords. Thereafter, my lords, I have produced 2 judgments of this honorable court wherein the courts have held if there is no acknowledgement of having received the rejection order, that cannot be construed as acceptance, my lords. In that context, my lords, 2 judgments what I had produced. One was WP 23419 of 2017 dated 18/9/2017, my lord, that I had filed it on 27th, my lord. In that, my lords, the Honorable High Court have held that if the notice, the rejection order is not received through registered court acknowledgement due, that cannot be construed as acceptance, my lords. The similar view has also been taken in the judgment of this Honorable Court in WP 1722 of 2021, my lords. In fact, my lords, I have on 2019, I have been informed about the rejection order, which have also been produced, my lord. The department have written to me saying that your order has been rejected. By a detailed response has been given, pursuant to which immediately I filed revision.
Mahendra, what do you have to show that it has been received by them?
We have no document to show that it has been received by them.
And how do you say it has been received?
They have not complained about that even in the revision.
In the revision, they said that they have not been informed. They have said that.
No, Lord. They have not said so in the revision. They files revision after lapse of 3 years. The reason assigned is, Lord, your Lordship may kindly see. All that they say is the deputy conservator Pola's letter.
The applicant. The said fact is not intimated to the applicant. It's only a small box where they have to write.
Which fact? That is the fact of the letter 1610-2010 written by the.
Now it's up to you to show that it's been informed, Mr.
You are
Mehta.
taking this ground, you have to
You
prove
cannot
it.
put it on there.
You have to prove it.
Lord, they have to plead for condonation of.
Now it is for you to show that they have served it on them.
No, we have no document, Lord. We have document for having sent. For having served on them, we do
Should
not
we
have
take
it.
it that we have no document and proceed that there is nothing?
That is the fact, Lord. That's my instructions. For having served them, we do not have any document.
Then the
And
decision
moreover, Lord, may I make a submission? Moreover, Lord, even if it is considered, it is not a saved application for a simple reason that, Lord, prior to 12/8/2016, since it is a Goma land, no joint inspection has been received in the office of Deputy Director of Mines and Geology. Therefore, it is not a saved application.
My lords, if I may submit,
then Thirumalesh's case would not apply?
it is squarely applicable.
No, my lord.
It's
It
squarely.
is not a case of no objection. It's a case of joint inspection. For joint inspection, there is no deeming fiction.
Joint inspection has not been done. Madam, joint inspection has not been done.
My lord, joint inspection has been done, my lords. If my lords permit, I will produce the RTI letters where it is shown that joint inspection has been done. My lords.
You cannot be taking adjournment every time to produce
No, my lord,
document.
that is not my endeavor, my lords. In fact, my lords, if I can take my lords to the judgment which I have produced on 25th of January, my lords, in that I have.
The contention of Mr. Mahindra is that joint inspection has not happened. Now you're saying you'll produce a document. Every time it comes up, you say you want the time to produce document.
My lords, my only contention, my lords, here is to let the revisional authority decide my application in terms of Thirumalesh, my lords. Ultimately, my lords, I am governed by what has been fallen from this honorable court in Thirumalesh judgment, my lords. Let them consider in terms with Thirumalesh judgment, my lords. They cannot throw away my application on the ground of delay when there is no acknowledgement of having served to me, my lords.
The petitioner is before this court seeking for the following reliefs. The main contention of the petitioner is that the petitioner has not been communicated with the date, madam?
My lords, the date of rejection, my lords, date of rejection is on
18/11/2016.
Order of rejection dated 18/11/2016. As regards which the revision was filed under Rule 53 for the KMMC rules, which came to be rejected by way of the impugned order dated
5/6/2021.
2020.
Only on the ground of delay.
Only on the ground of delay. The contention of the learned counsel for the petitioner is that the revision authority has not considered the fact that the order of rejection had never been communicated to the petitioner. Thus, there was no question of delay on part of the petitioner. And the authority ought to have considered the revision petition on the basis of the decision of this court in Thirumalesh's matter. On inquiry, learned AGA, C.S. Mahindra, learned AGA, is unable to place on record any document establishing service of the order of rejection on the petitioner. In view thereof, we accept the submission of the counsel for the petitioner that there is no service of such a notice, and the regional authority ought to have considered the effect of such non-service and consider the matter in persons of the decision of this court in Tirumala's court, more particularly para 47 to 49 thereof. Thereof, we pass the following order. The certiorari is issued. The order dated 5/6/2020 passed by respondent number 3 in reviewing application number 82 of 2019-20 is quashed. The matter is remitted to the regional authority, respondent number 3, to be considered in accordance with the decision of this court in Tirumala's case, more particularly at para 47 to 49 thereof. Within a period of
Grateful,
3
my
months from the
One
date on
submission.
a copy of this order is placed before the jury. Yes, Mr. Mahendra?
The revisional authority, apart from considering the delay, they have considered Rule 8A also, because it is not a free area for grant. That is
Let
the
him
final.
consider it in terms of Tirumala.
Because
Pass a fresh order. Pass a fresh order in terms of the.
Grateful, my lord.
26.
Similar order, my lord. Similar application.
Well, only the date has to be checked.
Please, my lord. Grateful, my lords.
27.
Lord, I appear for the respondent.
Appear for the petition in the connected case minutes.
Lord, in this matter, my lords have granted an interim order on 7th of December 2021. That is in writ petition number 20736 of 21. Lord, the interim order that your lordships granted was direction to continue the earlier process of registration. The issue, my lord, in this case is a challenge to Rule 33 of the Karnataka Motor Vehicle Rules, which was amended by us on 31/10/2021, by which, my lord, we have allowed certain dealers who are identified through a mechanism that we have to be nominated as registering authorities. There's some disturbance.
Is there any urgency today?
Of course, not the whole difficulty for us is the entire process of dealers registering has come to a halt, and this practice has, as a matter of fact, been continued for in at least 8 states in the country, where dealers are the registering authority for the purposes of registering new vehicles.
My lords, may I appear? I am appearing for the petitioner in the same petition wherein this order was passed. The urgency, my lords, before which I would like to bring to the notice of this honorable court is that the state is yet to start the execution of the project which was being halted in pursuance to this notification. One clarification, my lords, which I may want to also bring on behalf of the petitioner is that insofar as the Rule 33 of the state is concerned, that is not where the petitioner has any grievance. The petitioner's only grievance is limited to the fact that so far as the issuance of vehicle registration certificate is concerned, the same should be only in accordance with Rule 23A, which provides for the issuance of the vehicle registration certificates through the smart card or through a laminated.
Mr. Counsel, what is the urgency of the question?
It is to be heard finally now, but
Yes, but I heard finally,
the urgency is, my lords, that they are not implementing in spite of the last orders being passed by the honorable court.
Go and file contempt. What can
the
we
state
do?
is apparently in contempt of the orders of this court.
There is, my lord, I must make one submission, lord. So far as this petitioner is concerned, he is, my lord, someone who has been given a contract. He now challenges the action of the state in amending a rule, which, my lord, is really with respect to issuance of.
Any vacation application?
I've made an application, lord. I've made an application. So if your lordships, my lord, would consider that application any other day, my lord.
Application.
20736.
So far as that application is concerned, my lords, that's absolutely a case whereby they're seeking a review of the order.
For production of documents.
There's an application filed on 23rd December 2021 in WP 20736.
Let the objection be filed to this. Consider.
My lords, may I humbly request this one aspect?
Who appears in 20736?
I am appearing in that matter, my lords. I am appearing for the
Have
petitioner,
you-
which is
You file objection to the stay vacation application.
my lords. If that, my lords, in the meantime, there are just two submissions my lords have made. One is with regards to the issuance. If I may bring to the notice of my lords,
Meantime, we are
filed
not considering anything, or we have to consider the application of vacation of interim order. If we don't want to file objection, let the stay be vacated.
My lords, may I then request for an early date? We will file it by next 2 days and the matter be taken up in the next week. Because the vehicle owners,
Petition praise for is allowed 2 weeks time to file objection to the stay vacation application. Give it date.
10 March.
Can I request
my lords, may I seek an early date, my lords? For the one simple reason, my lords, may kindly see a particular document that we have brought on record. The issuance of the VRCs is happening on papers, which is illegal.
Can it be on 14th or 15th, my lord?
15th.
My lords, if it could be in the month of February itself.
All right. 16-2.
Wait, I'm grateful.
Obliged, my lords.
So I beg to appear for the petitioner's counsel. But the appellant was appointed as the assistant professor of dairy economics, my lords, and the second respondent, university. Third respondent, my lords, filed the writ petition questioning my appointment, my lords, on the ground that as per a GO, my lords, of 2005, the age limit could not have been increased to 59. Kindly come to the prayers, my lords, at page 28. Para 2, the first relief sought, my lords, is a writ order or direction striking down the notification dated 9/5/2005, read with notification dated 1/3/2012. My lords, this was the notification by which the age limit was increased to 59. Now, importantly, at para 7, the writ petitioner gave up this prayer. Para 7, my lords. Memo dated 4th.
Who is for respondent?
Lordship, yes to issue notice. Oh, he gave up the prayer, my lords. My appointment has still been quashed. I have been in service since 2019.
All right, Leonard AGA.
R1.
You accept notice for
R1.
what about 2, 3?
2 and 3, Lordship.
We are the contesting respondents.
Leonard AGA shall accept notice for R1. Copy of writ petition be served on Leonard AGA. Issue notice to R2 and R3. PF within 1 week. List. Give a date after.
Lords, now a fresh recruitment notification may be issued, my lords. I will be out of office time.
Let that be issued first. You challenge it.
So, lords, your lords, that is pursuant to the direction of the single judge. Lordships may kindly direct status quo to be maintained. As on today, my lords, they have not issued that notification.
Then we will have to first admit the appeal. If in case they issue any notification, then you file the application. Then we
Lord, then I will be out of office, my lords. Please see, having given up that
they have not yet issued any advertisement. Let them first issue. You bring it on record. Then we can only say all this.
Lords, I am continuing in the post. This is a peculiar case where the prayer was given up. Having given up the prayer, my lords, the learned single judge, in fact, could not have disturbed my appointment. Therefore, till they come before your lordships.
Third, admit the issue notice. The notice for respondent number 1 shall be accepted by Learned AGA. The steps for issuance of notice to respondent number 2 and 3 shall be taken within 1 week. list. After list on, give a date after 3 weeks. 9th March. Considering submission made by Learner Council for the appellant. As an interim measure, it is hereby provided that the status quo with respect to the appellant shall be maintained till next date of listing.
Grateful. So grateful.
29, Prahalad.
I appear for appellant, my lord. I appear for appellant, my lord. In this matter, this is scheduled Karnataka scheduled caste and scheduled tribe land prohibition transfer case. In this case, the learned single judge in WP has quashed the orders passed by the respondent number 1 and 2 after inquiry of respondent number 3. The violation of section 4(2) has been happened. Within 15 years, they have sold the property. I am the original legal heirs of the original grantee. Hence, I have challenged this order, my lord, on 9/12/2021 passed by the learned single judge.
I'm appearing for Caveator Council.
Yes, you appear.
Yes, I'm appearing for the Caveator. One of the respondents I'm appearing through Caveator. Other respondents.
There are 9 respondents, my lord. 1, 2, and 3 are the for state. R1 to R3. Violation 4(2) of the PTCL.
Sale happened in 1967.
Please, my lord. 67 and subsequently on 15/6 and subsequently within 15 years they have sold this one to 1955. It was
When did you
granted.
challenge it, Mr. Counsel? When did you challenge it?
21/7/67 it was sold within 15 years. So 4(2)
When
it
did
is
you
violated.
challenge it is the question, Mr. Prahlad.
My lord,
When did you challenge it?
that was challenged by them, my lord. I have challenged that it is a suo motu order, my lord. Suo motu by the respondent number 2. On 15/6/1982, there was a report submitted by the Tahsildar that the sale is in the violation of 4(1), 4(2).
Orders were passed on?
It is in favor of the appellant, sir.
1987 orders was passed.
3 WP was filed. Thereafter, Assistant Commissioner passed an order on
In 1987, you
4(3)2.
passed an order.
Judgment of the apex court has been applied. There is nothing wrong with this order.
My lord, it is in violation of section 4(2), my lord. Within 15 years, it is sold. Subsequently, it wasn't restored by the respondent number 1 and 2 in my favor. And they have filed the 3 WPs. This is the 3rd WP which they have filed. In this, they have succeeded in quashing that orders passed by the respondent number 1 and 2. That is dated 31/1/2020 and 3/4/2012.
You mean to say the purchaser has filed the writ petition in 2020?
Yes.
Yes.
Order itself is passed by the Deputy Commissioner in 2000.
Deputy Commissioner and the Commissioner.
After the remand by this Honorable Court and decided that.
You place your submission on record, Mr. Rajgopal.
Yes, my lord, I will place it on record.
To the respondents. Shri Mahendra Learned AG accepts notice for respondent number 1 to 3. M.R. Rajgopal, Council accepts notice. Give it a.
H.N. Basavaraju may kindly be sent.
Say H.N. Basavaraju accepts notice for respondent number 7. Issue notice to the other respondents returnable by.
Interim orders, my lord. Interim orders may be granted, my lord, till such time. I beg for interim orders, my lord.
Meanwhile, the impugned order dated 9/12/2021. Passing WP number 3566 of 2020.
Much obliged.
Date of hearing.
Much obliged.
Interim order staying learned single judge order, my lord, only with reference to implementation of that. We are in possession. They cannot execute the order of the Assistant Commissioner taking advantage of the interim order. We are the purchasers, we are in possession.
No, there is a violation, my lord. It may be examined, my lord.
Your
It may be
lordship,
examined in the final hearing.
status quo to be
It
granted.
is made clear that the possession of the
Possession, we are in possession.
respondent
No, no, no. We are in
shall not
possession.
be disturbed.
Purchasers are in possession.
No, my lord, we are in possession.
No
That
material.
we'll have to decide after arguing. If you say I am, we are in what I am. Help Mr.
Please, my
Prakash.
lord. Please, my lord.
Let
It may
it
be
decide.
on merits. It may be
Parties may be asked to maintain the status quo regarding everything.
That is what we have ordered, Mr.
Very well, but I'm grateful.
Much obliged.
My lord, I appeal for the
Regarding
I appeal for the petition in this case, my lord.
The date in the previous matter.
10-3.
Obliged.
13.
I appeal for the petitioner in this case, my lord. I have challenged the order of the deputy commissioner in allotting 30 guntas of land, which belong to the respondent 7, 8, and 9 association, which was granted way back in the year 1910 in favor of London Missionary Society by the erstwhile government of Mysore. The then deputy commissioner and the president of the town municipalities. My lord, the facts are this, my lord. Your lordship may kindly take annexure.
Is this a public interest?
Annexure A1. Please.
Is this a public interest litigation?
Yes, my lord. Yes.
How can you challenge
Yes,
an order?
yes.
They want to challenge it, they will challenge it. They are parties to it. How can you challenge an order passed as well as somebody else?
For the reasons best known to the respondents 7, 8, and 9, since they have slept over the matter, not taking any action, not prosecuting the matters properly by producing the documents. So, the petitioners, they are born and brought up from Chikbalapur, and their parents have served in that society. Therefore, out of I have, your lordship may kindly take page 15. I have stated.
You know the application which has to be filed, Mr. Ashwat Nayana, you can do that. The petitioner is before this court seeking for the following release.
Please, Lord. No, your lordship may kindly take page 15, where I have stated the reasons why the petitioners have come before this honorable court. My lord, they allowed the proceedings to be dismissed. They have not filed appeals. They have not challenged the order of the assistant commissioner. They have not challenged the order of the deputy commissioner. So far, no steps have been taken by them.
What is public interest? What is public interest involved in this?
The public interest involved is to retain the property which belongs to the Christian community, that is London Missionary Hospital Society was granted by then Maharaja of Mysore in the year 1910. Your lordship may kindly take Annexure C is the order. Annexure C.
Sorry, sir, this cannot be in the public interest.
In page 42 is the. Please, my lord. Your lordship may kindly take Annexure A2, ink page 39. The topography of the land is stated. Your lordship may kindly take page ink page 39. The plan of new extension of Chikbalapur town. Your lordship may kindly take page 39.
You may have
Respondent 7, 8, and 9 are the custodians of the records. They ought to have protected the property of Christian community. Since they have failed to take any action, not even a single attempt they have made, they have allowed the suit to be dismissed for default. They have allowed the appeal to be dismissed for default. They have not at all questioned the order of the assistant commissioner. They have not questioned the order of the deputy commissioner. How? See, we the people, public spirited people, we cannot allow things to go on like that. The crores worth the property is being knocked off. That is the reason, my lord, the petitioners have come. My lord, the petitioners are the retired people, they are pensioners,
And the third petitioner is a doctor by profession. The first petitioner is an officer working in the state accounts department. The second petitioner is a retired teacher. So they have come forward without taking any help from any quarters. Well, Your Lordship may kindly allow me to, on the merits, say Your Lordship come to know why the petitioners have come before this court.
Forward, how can this? Sorry.
Petitioner is before this court seeking for the following relief.
Please, my Lord. Your Lordship may kindly take
We have heard you,
connection.
Mr. Justice.
Here
There is no
too.
way when we start dictating the other, you will start arguing the matter.
Lord, I am sorry, my Lord.
Oh, we have heard you, we have understood you. Now let the order be passed.
My Lord,
The third
my Lord,
respondent.
may I just
We have heard you, Mr. Ashwatthanaran.
Enough.
no, Your Lordship may kindly look at the annexure C.
Dismiss the appeal filed by the seventh respondent, the Church of South India Trust Association. If at all, the petitioners are in the present petition seeking to espouse the cause of the seventh respondent who was a party to the said proceedings. If at all anyone is aggrieved by the same, it is the seventh respondent who is required to challenge the said order and not the petitioners by way of public interest litigation. That too by arraying the said Church of South India Trust as a respondent number 7.
The writ petition is misconceived.
In view of the above, the writ petition claim that public interest litigation is completely misconceived and is dismissed at the stage.
Number 31. Yeah, Ravendra.
Yes, what is this?
I'm appearing for petitioner counsel, my lord, in this. Some
New
prayer is not correctly molded. Your lordship can actually grant me sometime. I will do it. I will instruct the advocate on record to do it.
Yes, Mr. Rajgopal Amar, the senior advocate appearing for petitioner, wants a short accommodation. On his request, the case is adjourned. Just after 2 weeks, give it date.
7th March.
Next.
Number 31, 32.
That in 32, I appear for Mr. Gautam. And in 32 bar 1, 2, 3, and 4, my name may kindly be replaced with that of Mr. Gautam since I am designated now. In WP number 12954, Mr. Uday Valla appears for Mr. Gautam. This batch matters, Lord.
The registry is directed to substitute the name of Sri Basuraju S in this batch of matters with the name of Sri Gautam AR as that appearing for the petitioners in the respective matters. Released on.
Lord, the state has to file the counter in the first matter. Lord, the interim order may kindly be granted because in 32.1, 2, 3, 4, 5, and there is an interim order granted by the learned single judge, staying the demand notice and also the circular, the challenging the constitutional validity of the BBMP Act on the ground that it takes away the exemption.
Give a short date. We will consider it again on the next day.
But in the connected matter, there is already an interim order.
Let the names be shown properly.
My lord, in 32.4, my lord, the stay may be extended, my lord. I appeal for the petitioner, my lord.
The interim orders earlier granted is extended till next date of case.
But in my matter also, in 1, 2, 3, may make one submission, my lord. But all the petitioners are similarly located, situated, and the interim order is directing that the BBMP shall not enforce the demand notice, except the first petitioner.
Let your assisting counsel come, we will consider your submission.
But in the first matter, I am appearing for Mr. Gautam Miller. In the first matter, there is the interim order will kindly be considered because in all other matters, there is an interim order. In the first matter, Mr. Gautam Miller, I appear for Mr. Gautam.
We are saying we'll Next time
Next
we'll
week.
consider, we have not seen the file. File has gone from here.
Yes.
33. Sir, Kambi.
Appear for the petitioner's counsel.
Yes.
Emma Nayak.
Since I appear for the petitioner's counsel in this matter,
That is why. Leave it as it is.
Naik will have it on another day.
Lordship, please. In the meantime, Lords, there are series of orders made where there is a direction to produce the records. Let government advocate produce the records.
The list.
18th March.
In the meanwhile, the AGA is directed to produce records as directed.
Lordship, please.
34.
But I represent the petitioner's counsel in 34.5.
I appear for petitioner in 34.1 minutes.
We will have it again today. No time left now.
Any date connected to the court minutes.
Disposed of, not a memo for withdrawal is filed in 2 cases.
Minutes 34.3 and 34.4 I pay for petitioners. I filed memo for withdrawal of the petition minutes. Those 2 petitions may be withdrawn minutes.
34.3 and 34.4.
Please, my lords.
Memo for withdrawal is there?
Yes.
Memo for withdrawal is allowed. The petition is dismissed as withdrawn.
It's in serial number 34, the main matter. I filed memo for withdrawing the objections that are earlier filed. And I also filed a memo stating that I have no objections to allow the petition that submission may be recorded minutes and I leave it to the court.
Lord, I appear in 34 for the writ petitioner. Lord, I am the grantee of a mining lease. Lord, the current...
Again, we can't consider it today. And afternoon there's a different bench.
The Lordship, short date, my Lord. Yes. Only in 34, your Lordships may have to just notice one earlier order and dispose of this matter, my Lord. It's no contest in this case.
Give the file. Give the file.
May I explain what happened, my Lord? I applied, I'm a cement company, my Lord. I applied pursuant to a notification. And, my Lord, the government issued a notification granting me certain lands. Now, my Lord, this third respondent who is now withdrawing the challenge, she claimed that she owns some area as patta land. And she made an application and grant was made to her, some portion of the land. That was what was challenged by me. Now, my Lord, we have reached a settlement. There was an interim order, my Lord, granted by our Lordships on 2/11/2016, by which, my Lord, the Honorable Court directed that lease should be executed in my favor, excluding the disputed portion. Pursuant to that, lease is executed in my favor. Now that they have withdrawn their objection, my Lord, pursuant to a settlement, your Lordships could, my Lord, dispose of the writ petition as objection not surviving, with a direction for the balance they could execute the lease deed in my favor.
And also that I withdrawn my petition in 30.
Just a moment, Mr. Nagaran, there's some problem with the order sheet. This is a different number.
2/11/16 in WP 32929.
It's 33, 34.
32929. Give the file.
Serial number 34. Kindly peruse the order of 2/11/16.
You mean to say the 44.43 hectares also is being sold to you now?
Yes.
Lords, may I make one
The
submission?
only reason, my Lord, why the Honorable Court, my Lord, was made this reservation is there was an objection from this lady saying I am entitled to it. So, my Lord, therefore the court said, leave aside that, execute for the balance. Balance, it has been executed.
Since I was the landowner, I had objected and also filed another petition at 34.4. That also I am withdrawing. So I have no objection to allow his petition.
Yes, Mr. Panindra.
Lords, please see, we are appearing in the connected matters. We had also had a dispute. Now, my lords, we do not know whether this 44 acres includes my area because we are all patadars.
It doesn't
Our
include.
understanding was
To be made clear.
These are
if
private
it
lands.
is
That is
included,
saying that it doesn't include your land.
Doesn't include.
These are private lands, my lords.
no. My lord, so far as the connected matters, if it does not include my lands, I have no issue. Because it should not be understood that 44 hectares is pertaining to the item numbers which somebody wants to withdraw.
Respond number 3.
May I make a submission?
Yes, Mr. Mahendra.
Even if the respondent number 3 withdraws his objections, Lord, notification at annexure A is in favor of R3. Unless a separate notification is made in favor of the petitioner, it will not inure to the benefit of the petitioner.
It can be done, my lord. It's a formality because government has issued the notification for
Now, all that he can withdraw this lot of writ petition.
That is all. Why don't you withdraw the writ petition? That is all.
my lord, if I withdraw the writ petition, my lord, then this by pursuant to the interim order, my lord, one extent was granted to me. Your lordships could kindly consider this, my lord. In case, my lord, since the third respondent is withdrawn, the government should make a consequential order, my lord. That's all that I'm saying. Because my prayer in the writ petition.
Whether that would inure to your benefit, Mr. Naganan, would be the question. It could go to anybody else.
No, it can't go to anybody else, my lord, because I have applied pursuant
Let's
to.
consider it on the next day.
18 March.
18 March.
Lord, serial number 34.2 is concerned, my lord.
May I make a serial number 34.1 and 2 is not connected with.
They are not connected, my lord. I agree with the government advocate, means.
They are not.
They are not connected. 34.1 is not connected, means.
Even
34.2.
Mr. P.R. Ramesh, counsel for petitioner, submit that the case is wrongly connected. Office shall dealing and list separately. Write this in 34.1 and 34.2.
Please.
My lord, a short date may be given insofar as serial number 34 is concerned, my lord.
Sorry. So next.
35. K.C. Shant Kumar.
35, my lord, I appear for the petitioner. I'm seeking your lordship's indulgence to grant me an adjournment. I need to get ready in the matter.
Adjourn on the request of counsel for petitioner. Mr.
31-3. Serial number 36.
36, I appear for the petitioner, my lord. Herein, the petitioner is represented by a managing director who has now expired, my lord. Therefore, a new managing director needs to be brought on record. I request permission to carry out necessary amendment in the cost title, my lord. I have filed a memo in this regard, my lords, on 20th January 2021 also.
The petition has been filed on behalf of the company.
Yes, my lords.
Party's name?
Chitrapur Tiles Private Limited, my lords.
Again, on the request made on behalf of counsel for the petitioner, so we enable him to move appropriate application.
Memo has been already filed, my lords.
Give it date.
21-3. 37.
I appear for the petitioner's counsel, my lord. This is a matter relating to the restoration of the palace at Madikeri. There was a direction to the Tahsildar Madikeri to file an affidavit regarding the tombs of the Rajas, my lord. 6 months over, he has not filed the affidavit. The Tahsildar of Madikeri, my lord.
Give a date. No time is left today.
Please, my lord.
Just on.
22-3.
What is these applications?
Applications are for directions and other.
Not in your case.
Please, my lord. Please.
Lord, I may be permitted to submit on behalf of the advocate of the petitioner, my lord, serial number 38. The two interim applications of my lord is on 8/7/21. The Honorable Court permitted the students to take the exam.
Third on this. Third on IE. List on. Give a date. Short date.
My lord, some urgency was.
We are fixing date, mister. Wait, have some patience. Yes.
39.
Your Honor, may it please, Your Honor. I appear in 39. Your
What is
Honor.
the application?
Your Honor, Your Honor, unfortunately, there has been some technical error. My application for posting has already been allowed by an order dated 25th January by Your Honor
For
bench
the
only.
petitioner applicant informed that case is wrongly listed today.
Yes. And my matter is listed
Is
for
the
9th
case on the
February, Your
date
Honor.
fixed? Date fixed pe aayega. It will come on date fixed.
Number 40.
Yes.
I'm obliged, Your Honor.
Lords, I appear for the petitioner, my lords, serial number 40, my lords. Lords, it is for memo for posting, my lords. Lords, it may be posted.
Just wait.
Lord.
All these 40, 41, 42, give a date.
Lords, the urgency in my case is not serial number 40, my lords.
Just have patience. Give a short date.
15-2.
Obliged, lords.
Obliged.
Court of sir. Court of sir. Court of sir. Court of sir. Court of sir.
ಹೇಳಿ ಸರ್.
ಸರ್ ಅದು ಇತ್ತು ಮೆಮೊ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್ ಹಾಕಿ ನಾವು 3 ದಿವಸ ಲೇಟ್ ಮಾಡ್ಗ ಅದೇ ಡೇಟಿಗೆ ಆದ್ರೂ ಕೊಡಿ ಸಾಹೇಬ್ರೆ.